good morning, everyone. And it is a matter of great pleasure and privilege for me to introduce the report that we are presenting today before a very learned audience. And to bring in on this platform a number of very experienced practitioners of law, activists who are concerned about issues of worker safety in the labor markets of our country, and especially in Gujarat, where I believe the rates of accidents and injuries to workers are probably one of the highest anywhere, in our country. Ajivika Bureau, which I represent, has been working in the labor corridor of Rajasthan, Gujarat, Maharashtra for last over 15 years now. We are present in the source areas, rural tribal areas of South Rajasthan, as well as in the bigger markets, labor markets of Gujarat, such as Ahmedabad and Surat. And in Ahmedabad, our work has brought us to understand and intervene in the very arduous situations of workers in the textile sector, particularly in the textile hub of Narol, a massive cluster of small units undertaking processing, dyeing, washing of clothes, and which finally end up in a larger unit making garments and apparels. The number of workers in Narol, which this study also concentrates on, runs into thousands. These are migrant workers from Uttar Pradesh, from Bihar, Jharkhand, Rajasthan, Madhya Pradesh, and these are workers largely, employed, retained on very informal terms. The size of the units itself is quite small, but in the vast hinterland of very small units, there are 30 to 35 larger units that are, in a way, shaping the market, both of production, manufacturing, and supply from the Narol cluster. Now, this cluster, we have seen and have dealt with several cases of injuries, trauma, electrocutions, burns, fire accidents, which have remained largely unreported, undocumented, and therefore uncompensated by employers. Our own legal aid work, legal aid cell in Ahmedabad, supported by the center in Udaipur, has recorded, documented, and also mediated in several such cases. There are also, I believe, well over a dozen cases that have been taken to court in order to obtain fair compensation for workers who have been dealt a debilitating blow in these units of Narol. So the report, what it does is to generate and capture evidence from Narol, the very, I would say, very powerful evidence of both employer negligence and the reality of injury in these conditions, and documents what happens to workers once they have gone through one such episode and one such experience. What the question this report seeks to answer or seeks to explore is what are the opportunities within the framework of law that remain challenged and that can be acted upon more, I would say, rigorously going forward. And whatever we understand from Narol is applicable to many, many markets, many labor markets, and similar work conditions in other parts of the country, including in Gujarat. The study has gathered empirical data, and I must thank our colleague Shubham Kaushal, who will present this report before all of us. Over the last 1 year, especially during COVID times, it was not easy, which is why the role of the Karkhana Suraksha Sangh in Narol, which is a trade union of workers in this region, became extremely important. They were the primary data collectors, and they analyzed the data for us. They helped us to understand the connection between accident and the conditions of work and what happened, laying out for us the trajectory of workers who have suffered, thereafter. So it's a partnership between Ajivika Bureau and the union, and Shubham will present the report to us. Shubham is a young lawyer with immense interest in human rights, environment, urban issues, And now, since he's been working with us in the issues of informality and precarity of the workforce that works and contributes enormously to the economy of this region and the city. So I'll hand over to Shubham for now, and then we'll follow it up with an introduction to the panel that will help us explore various dimensions of the study and its implications. Shubham.
Good morning, everyone. I'll be presenting a short summary of looking beyond fire extinguishers. And the report is mainly a documentation of the prevalent factory floor realities and labor practices that produce these fire hazards in textile processing factories located in Narol. Narol is a textile industrial cluster located in the southeastern periphery of Ahmedabad. It is spread in over 2,000 units, out of which 35 of them are large-size factories employing anywhere between 500 to 5,000 workers. Small and medium-sized units feed on subcontracted and outsourced orders from these factories and perform specialized tasks such as washing, dyeing, printing, ready-made garment stitching. The industry is highly informal, and it runs on the brunt of the cheap labor provided by migrant workers who come from neighboring states. Hazardous working conditions are also a prime feature of this industry in Narol, with frequent cases of injuries, accidents, and fire outbreaks. Now, reactions to fire outbreaks, that is particularly those that result in deaths, is predominantly on making changes to the structures of the factory, installing fire extinguishers, monkey ladders, fire exits, training workers, and immediately compensating the families. But rarely do these reactionary interventions result in changes to the hazards faced by workers in their day-to-day routines, which in turn produce and enable these large accidents. According to a report by Indian Express, 322 industrial accidents have occurred in Gujarat in the last 2 years alone, which also evinces the lack of this basic workplace safety. So therefore, this study seeks to bring forth such routine factory floor realities that we've seen in Narol, where Ajivika Bureau has built its operational presence over the last 10 years. The report does this by firstly foregrounding workers' perspectives on hazards and safety. Second, it focuses on fire hazards as a part of workers' safety. And lastly, it compares these realities with the provisions under the Factories Act and Gujarat Factories Rules 1963. The study was undertaken with the participation of 95 workers who are employed either as helpers, operators, masters, supervisors in processing departments in these factories, particularly large-sized factories in Narol. Moving on to the findings. Workers in higher roles were found to be more likely to be on the payrolls of the factories. Interestingly, some such workers were also found to be dummy contractors who would hire workers on behalf of the factory. This practice would allow factories to hire more workers when demand increased and arbitrarily fire workers during lean seasons. We also found that often workers who are hired in this way are denied access to facilities at the factory. They also lack adequate shelter, which are their entitlements under the Factories Act and Contract Labor Act. And this is because they're not regarded as employees of the factory, but that of the contractor who hired them. In Narol, it is common to spot workers hired to operate boilers and effluent treatment plants living just outside factory premises in shacks without access to potable water, toilets, creches. 12-hour work shifts are the norm, but overtime compensation for the additional hours is rare, and it was only found in a few cases where the workers were on payrolls. Interviews revealed that workers are not given pay slips and they lack explicit proof of employment. Because of this, they're unable to establish continuous employment to claim social security or even protection under Industrial Disputes Act. Lack of fire compliances. Firstly, accumulation of fabric dust on wires, switchboards, electrical panels, and light fittings was reported by workers to be rampant. At the same time, 71% of the workers also reported exposed live wires, broken sockets, loose electric connections at their workplaces. Allowing these to coexist reflects a failure to eliminate and prevent creation of fire hazards. Now, with regards to firefighting equipment, while 74% reported that their work premises had fire extinguishers, only 47% had seen these being serviced and tested. 99% of the workers reported that there were no fire hydrants in their workplaces. Regarding fire exits, factory layout is often complex with various sections and enclosures. Vacant spaces between machines, passages leading to exits, doorways between departments were reported to be crammed with lorries, cloth rolls, chemical drums, and stacks of packed material, since machines are required to be kept running 24/7. Reflecting on this, 82% of the workers stated that it would take them 30 minutes to an hour for their factories to be evacuated outside of the premises in case of an emergency. But why is this so? 63% stated that they had only 2 exits in their vicinity, which meant that up to 250 workers had to disproportionately share these 2 exits. 98% did not know of any emergency protocols, such as finding the designated means of escape, operating a fire extinguisher. 95% of the workers stated that there were no alarms to warn them of fires or trigger an evacuation. Moving on to occupational practices. Chemical drums and containers are kept in close proximity to machines and passages and doorways outside the demarcated areas for immediate access so that orders can be completed as soon as possible and machines are continuously kept running. It is the manner of handling of chemicals that was unanimously voiced as a major concern by the workers. 98% felt that safer use of chemicals would improve their overall health. Irritation of skin, eyes, nose, throat, headaches, and nausea are common among workers. The job of obtaining, carrying, pouring chemicals is usually that of the helper, which is the lowest rank on the factory floor. They are highly exploited workers, hired without any contracts and paid very little weekly kharchis by their contractors. They lack prior training and are not even informed of the exact hazards present in this job. Containers in which they carry chemicals to the machines are often broken or corroded that result in spills on their hands and feet and on the floor. Chemicals are used in relatively small quantities and appear harmless, but over time, they gradually develop burns, cuts, rashes on their hands and feet, and their bodies accumulate these long-term health impacts. While there are regulations for scheduled hazardous industries under Factories Act and Gujarat rules, there is nothing explicitly applicable to other industries that involve use of hazardous substances listed under Schedule 2, such as those found here in the textile processing factories in Narwal. Fabric dust is another big occupational hazard for workers engaged in denim finishing work, since it generates a rampant amount of dust. In sandblasting particularly, particles lodge towards the eyes, nose, and throat at extremely high speeds, compromising on their respiratory health over time. Workers cope by tying handkerchiefs and drinking tea, which is a widely shared notion for washing down pollutants. The prevalent practices of cleaning this dust is incongruent with the prevention of accumulation of fabric dust, which can be said to be a requirement under Rule 66. But as a result of this manner of work, not only does the dust settle on electrical apparatus and create fire hazards, but slowly eats into the worker's health. Moving on to labor management practices. The inability to clearly establish employer-employee relationship and the informal nature of the employment precludes workers from raising safety concerns or even negotiating better working conditions. Workers, especially in the lower rungs, such as helpers, housekeeping staff, who bear a disproportionate burden of the absence of safety measures and protective care, were found to be most unlikely to raise them. It is because of their migrant status and the lack of support systems in the city other than their immediate employer or contractor, who is also the provider of their wages, food, and shelter. Apart from their immediate superior, they often have no information about their principal employer, factory managers, safety officers, or even the details of the factory where they were working. Those higher up in the ranks are not much better placed in this regard as well, since if they raise issues, they would be immediately terminated, laid off without wages, verbally abused, or intimidated in many cases. So therefore, there is also no participation of such workers in the factories. 99% of the workers were unaware of the existence of safety committees in their factories. However, this could also be because Factories Act only prescribes for safety committees to be constituted in industries with hazardous work, notified under its Schedule 1, which does not explicitly include this work sector. Moreover, representation of contractual or casually engaged workers is in these committees is highly unlikely since they're not considered employees of the factory. So contractual and informal relationships have thus resulted in transferring of health and safety onto the individual worker. Injuries are treated as the worker's own fault. The cost of this is also borne by the worker or their marginal contractor in some cases, as against the employer. Injuries and illnesses are a burden since they're akin to losing the day's wage. The subcontracting and outsourcing of work also passes on the burden of concerns beyond factory life, such as food, sanitation, housing, onto incapable contractors who are anyway operating at very low margins in a highly competitive sector. So what are the takeaways from this report? Firstly, the report shifts the gaze from an oversimplification of accidents towards the daily factory floor realities and labor practices that enable them. By doing so, it suggests a move away from swift technical solutions and highlights the reactive approach of the state to only calamities. Secondly, it shows that workers are denied safety and health in multiple ways, such that it has resulted in a widely shared notion of risk being omnipresent among them. Thirdly, it finds that though factories appear to be visually compliant, but the areas invisible to the outside are ill-equipped with even basic workplace safety that turns them into these lethal sites. And lastly, there are various shortcomings in the law, such as absence of regulations of hazardous substances in non-scheduled processes, access to adequate and reliable grievance redressal for workers, which becomes a failing point of the existing law.
Thank you, Shubham, for the presentation and for a very powerful presentation. I'm very pleased to note that this sets a very, I think, very important kind of a foreground to the discussion that will follow. The tougher task of moderating the discussion is over to our friend and colleague, Osham Roy. Osham is a very eminent trade unionist from Gujarat. He's been very active in the whole human rights and occupational hazard space. Osham has been the founding member of National New Trade Union Initiative, the founding president of Chemical Mazdoor Panchayat, which has led actually several very significant and iconic union negotiations in Gujarat. We were very privileged to have Osham as an advisor to the study. So he understands the region. He's worked there in the past and he understands the industry and the players in it very well. And as a founding member of the Asia Floor Wage Alliance, Osham will help us take, I hope Osham will also help us take the recommendations of this study forward. So Osham, over to you. There's a very learned panel with you, Gayatri, who's been practicing in the Bombay High Court since the mid-80s and is now with the Working People's Charter. Jagdish Bhai Patel, who's one of the best known names on, on the whole occupational health landscape in Gujarat. He established the People's Training and Research Center here. We're very happy to have Mr. Priyadarshi with us. He's a retired Deputy Director of the Directorate in Industrial Safety and Health in Government of Gujarat. He's currently also enrolled as a Fire Safety Officer. So a lot of what we say will be very relevant to his experience. And finally, our dear friend Rahul Sapkal, who is an assistant professor at the Center for Policy Studies at IIT Mumbai. He is the recipient of the Faculty Research Fellowship and has written very seminal pieces on the whole issue of precarity and informality in the labor space. So thank you once again. Oshim, over to you.
Thanks, Raji, for giving me this opportunity to moderate this eminent panel. And in context of a report which Subham has presented, which is really fascinating in many ways. And I'm sure as we elaborate and deliberate about this, the implication of this report and also the issues that are coming in from our different experiences, we'll be able to really kind of give some clear inputs to how we should take this thing forward. So before I actually began the, ask people to really speak on issues, I was just going to give everyone a few minutes, maybe a minute or two to respond. Most of you have already now seen the presentation by Shubham, but you also have read the full report. You have also read the executive summary that he has given. So if there's any quick, initial comments that you want to make on the report itself before we go into the discussion, this is the time that you all can do it. And I would request every one of you to give it a minute or two to highlight some aspect of the report that you find very interesting or exciting. So I will begin with Jagdish because he's next to my camera. So I will begin with Jagdish. Jagdish, can you just give what you think would be the most pertinent issue that you see in this report?
Yeah, thank you, Ashim. I think this type of studies are very rare to come, mainly because on occupational health and safety, right, there are very few organizations which are working. So it is good that Ajivika Bureau has made it a point to work in this sphere of health and safety at work. So again, within occupational health and safety, people like us have been working consistently on occupational diseases. So aspect of accidents at work and that to focusing fires is, I think, a very important area where such type of studies are required. And what we have been seeing all over, particularly in South Asia, if we look at the fires taken place in Pakistan or Bangladesh or Philippines, we see the same thing that when the fire took place, the doors were locked and people could not run out because there were no proper exits. And even if there were exits, it were stocked with the raw materials and so on. Second thing, what we see during the fires is the storage of chemicals, which is not done scientifically, and that either is a cause of accident or fire, or it enhances the fire. So these are something very common, and the role earlier I used to think that most managements are interested in reducing this type of accidents because there's a good bit of property damage also. But from this study, we understand that they are not even bothered about the property damage, it seems. Otherwise, they would invest more into fire hazards to prevent fires. So this is a very sorry state, and I myself have worked for 20 years in chemical factories, where I have seen that the portable fire extinguishers are not maintained well. Workers don't know how to use it, and workers tell that, okay, if there is a fire, we will run out. Then we have to explain that if fire takes place, you won't be able to run out, even if you want. So workers are not also much aware about what happens when fire takes place. So I welcome this study, and I hope that we all will be working together for follow-up so that it does not remain just a study in our cohort. Thank you.
Thanks, Bhai. And before we go over to our friend from Bombay, Priyadarshi ji, आप एकदम you are actually at the heart of this system in some sense, and I think you have a lot of experience, and you also know the whole system in and out in many ways.
Yes.
So from that experience, but you're not responsible for it now in that sense. What would you really what would be the one of the key points that you would draw from this report? I think we'll come to the discussion as to what are the problems and how to solve it. But for the moment, I would like you to just draw one or two key issues that come from this report of Shubham has done. Over to you, Priyadarshi.
Congratulations to the Ajikawa Bureau for the conduct this type of the survey and prepare this report. Actually, for the Director of Industrial Safety and Health, we are facing a lot of problems. The most of the more than 60 to 70% posts are vacant till today. 5 posts, Joint Director of Industrial Safety. This is the key post for the investigation of the accidents, fires. But till these posts are vacant, there are 5 posts until there are vacant, only give the charge. Other thing is we have a lot of work from the government, from the collectorate. So we are not give the sufficient time for the inspection of the unit. Secondary, the inspector are not aware of the latest technology. They are not given the training to them. Actually, regarding the fire, in Gujarat, we are looking the industries registered under the Factory Act, and fire department and look out the fire safety. Gujarat government is introducing a Gujarat Fire Prevention and Life Safety Measures Act and a regulation. But what happened on last 8th July, government of Gujarat notified, they are declared one, published the notification on the 8th July 2021. In this notification, they are remove the factories which are registered under the factories. They have no need of the fire safety certificate or fire NOC from the fire department. So they have no need of the fire safety certificate. That's why these industrialists install the fire safety system. So that is the main problem for the Gujarat, because day by day they are always notified the new notifications regarding the fire safety, and present this matter are in Supreme Court and also in High Court. So now industries are not required the fire safety certificate NOC, so they are not installed these systems, and that's why it is a very critical problem for the Gujarat people. In fire department, all posts from director to the regional fire officer, all are on deputation. There is no permanent staff, and they have not even though the fire officer have not a sufficient knowledge about the fire safety system. They have no knowledge of the National Building Code, because National Building Code is the most required for the design of the factories, access way, emergency exit, firefighting system. But the Urban Development Authority is passed the plan, but they are not seen this main thing for emergency exit, access, etc. And the fire officer are not qualified in Gujarat. Most of they are completed their sub officer course of the fire, even though they are not aware of these rules and regulation also. Any industry have put 2 or 3 or 5 or 7 fire extinguisher, and they give the NOC. They are not install the fire fighting system like fire hydrant in the then extinguisher, then detector system, then water sprinkler system. And in factory only there are 4 provisions: section 38, section 66, 66A, and then chemical work schedule 19 part 3. But it is not sufficient for us, because they are not give a proper guide. Minimum, what is the minimum requirement? They are right in the act that you are provide the minimum requirement of the firefighting, but which type? They are not mentioning. Even though NIAT code, the National Building Code, even the Fire Act, they are not mentioning the firefighting system requirement. So there is a lot of problem in approval of the drawing. They are not mentioned the emergency exit, fire tender exit, their access route, height of the building, and that is lot of problems for the firefighting at the emergency. the fire tender cannot move or run in the factories. And most of main thing is the worker are not aware from the safety and fire. They are not give a proper training. Most of the every 6 months they are mock drill of the fire, but it is not possible in factories.
We can discuss this more when we have more elaboration with Rashidi. I just wanted you to, but I think you made a very, very pertinent point about the incapacity of the system, particularly the factory system, to address some of these issues. I'll go to Rahulji. You have recently written an article where you have actually said that it's like adding injury to already, you're adding to an injury that already exists. So, which is like almost saying that there is a systemic failure somewhere, and you being a researcher, you're observing this very well. What would be your immediate take from the from this presentation?
Yeah, thank you, Ashimji, and thank you, Ajivika Bureau, for this platform to share some of my thought. I'm really impressed by the report because the way it is very detailed in terms of the analysis of the data, as also putting forward the narrative and connecting with the labor laws that it has really brought out very, very, very detailed analysis. I will also give some suggestions, shortly, that how in the next phase they should actually do it in the large scale. Yes, you rightly mentioned about last year I wrote that article when the Visakhapatnam that incidents took place, and then also I have connected with the several other industrial incidents that took place in the country in the last like 7 to 8 years. Because last data we have, which is from the like India Labor Pocket Diary, which used to be published by the Bureau of Labor. That the data we had from the 2014 only, and there was also the underreporting of the data was very persistent, and only like less than 1% of the industrial injury used to be reported in the data. I think these studies have actually opened up that gray area where now we can actually report the industrial incidents, and most of the time when the casualty happens, and it has nicely documented in the report that most of the time the industrial injuries or the any workplace injury happens, they will categorize as the individual mistakes, and they will categorize as it's like industrial negligence on behalf of the worker, and they will not put any responsibility of the employer. So that gray, and we will like I used to teach in law school, so we will put them into the medical negligence claim, and then we will treat them into the like a tort law. But I think these reports will open up that segment, and it will make one step further, and it will reach it out that okay, these are also the industrial claims, these are also the workers claims, and we really need to come forward and really need to address this issue. Because more like if you look into the present labor code, because I think the report was written using the Factories Act, there are also overlaps, and also there are also not mentions about the labor codes also, and then how the labor code is also going to address the industrial injuries, or maybe maybe workplace injuries. So that also needs to be seen at a broader context, because 90% of the industrial injuries, that also I mentioned in my my article also, and it has also come out very nicely in this report. 90% of the industrial injury happens in the small and medium scales businesses, and we really need to take it very seriously, because only the larger company has the capacity to go and litigate matter into the labor courts. But when the 90% of the injury happens into the small and medium scale businesses, and also like a shops and establishment tax, the units governed in the shops, so that also needs to be we need to cover that gamut also as well. As apart from that, reports builds on very good narrative on the 4 sections. Though the data is very small, I can understand as a researcher it is very difficult to get these victims data, and they have managed to get 95 sample. But a document has identified that 97% of the workers are from the working on the casual and like a contract workers. 80% of them they did not receive any kind of a social security. It means already these workers are already part of the precarious workforce. The workplace is also deteriorating, and in this context I would like to bring it back like ILO's 97th conventions about the occupational health and safety, and then we really need to invoke that convention, and the literal translation of that convention needs to be mentioned into our labor codes or maybe labor acts. Yeah, I will come back on this point like in closely. Yeah, but these are my initial remarks. But I'm very impressed with the report, and consistently they have done it. And in the time when the Gujarat government was the first government who went during the pandemic and the lockdown time for the labor market reform or labor law reform. And this context, this study is very critical because it talks about if we do not have enough labor laws that will protect the rights of the workers. And one of the incidents is that these industrial injuries can go unnoticed and undetected. Thank you.
Great. So I would like now initial comments on this report from Gayatri. Actually, one of the best lawyers who has, there are lawyers who take up a lot of interesting issues at Supreme Court or High Court. But my experience and my respect for her is because she actually fights it at the most important arena where the laws of the workers, or where the labor laws and all these issues actually intersect in terms of day-to-day life of the workers. So Gayatri, you, with your immense experience both of the trade union movement, practitioner of labor cases, how do you really see this report can be, what could you draw from this report which would be a very legally important aspect?
Thanks, Ashim. And thanks for Ajivika Bureau for organizing this. I think it's a very apt time to do have a discussion on safety, health and safety. But coming quickly to the issue, as far as the report is concerned, again, I think it's a very good report, even though it's limited to the local area, but it sets out a guideline, overall framework with regard to similar issues that are taking place in other states also. So I would just focus on 2-3 issues. One is the issue of enforcement mechanism. The issue, what comes out very clearly from the report is a lack of enforcement mechanism, and that is going to increase with the introduction of these codes. If we look at the codes, these number of workers have been increased. Instead of making it applicable to all workers, now you have contract workers. It will be applicable only to those contractors who employ 50 or more workers. Then as far as Factory Act is concerned, it will be applicable only to those where 20 workers are engaged with power in factories with power and 40 workers without power. So again, without going into the details of the code, again, the issue of enforcement will become even more serious because small and medium factories will be left out, large number of contractors will be left out. Migrant workers it will be applicable only to those where 10 or more workers are employed. The issue of enforcement, again, as Mr. Priyadarshi had pointed out, the shortage of staff is definitely a problem. But the problem that we face also in Maharashtra is that the inspectors, and now it will become the inspectors and facilitators, they basically are not able to visit the sites. The plans that are prepared, as Shubham has pointed out, the plans that are prepared are not really looked into by the inspectors, nor do they have time to visit the sites. So plans are basically passed without even personally visiting the sites. And you find many of these factories where accidents have taken place is also because the plans were approved blindly without looking into various issues relating to exits, etc., etc. So enforcement mechanism is something which needs to be focused on, and the punishment that is to be levied on the employers as well as the enforcement agencies needs to be made more stringent instead of whittling them down. So the second aspect of this is that even the inspectors and the factory inspectors should be held liable if there is any breach of the provisions of the Act, and there is no such provision right now, or there's been no single case where inspectors have been held responsible for any of the violation that takes place by the employers. The second aspect is the overlapping of authorities. There's a lot of overlapping with regard to, as has already been pointed out, the fire inspector, the factory inspector, criminal law, whether criminal cases should be filed, whether cases under Factories Act should be filed. And in the process, nothing gets done and none of the employers are prosecuted, nor compensation is paid. Finally, the issue of compensation, most of the contract workers, as pointed out by Shubham also, are not covered. And therefore, when you talk of any accidents or injuries, compensation is not paid to them. And the only compensation that is paid is under the Compensation Workmen's Act, which is really minuscule because it's based on a particular formula based on age and income, which amounts to a paltry sum of compensation. So when we come to other issues relating to what are the alternate mechanism, I'll deal with these issues later on. But I think the most important issue, enforcement, overlapping of authorities and responsibility, the reduction of applicability to workers and in small scale and medium scale workers, and the conflict between criminal law and the provisions of the Factories Act.
Thanks, Gayatri. This has been great. I also, when I read the report and after the presentation that Shubham did, just want to bring out the aspect that in some sense this report is symptomatic of what is happening to not only Gujarat, which is a very highly industrializing state, but in generally the state of affairs in most of the other parts of the country, at the delinking of the industrialization process and to the question of safety and prevention of accidents. I mean, this is historically, there is an unevenness about it, but there has to be a linkage. And as laws and institutions develop, the things that actually the accidents and prevention should be much better off. That this delinking is a very, very symptomatic of what Shubham has showed. Narol is a very, very focal point, a zone which is like a hub of Gujarat's, in some sense, denim factory. Most of the denims are produced in that area. They're exported, and yet one can see almost abysmal situation of the condition in terms of the OHS framework. That's the point which I feel very important. And this brings back to me, and the other interesting part is the layering of the issues that he has brought in. And I would really like to, as we move into the discussion, focus on the two layers. One, and this is like, in the end of the day, there has to be an ecosystem for any enforcement or any mechanism. And I would say that, and this is something that we would discuss as we go forward, that an ecosystem of a OHS has to be a good law and policies. There has to be institutions that actually can convert that into a practice. And third, that there is an agency that feels and can drive this system into a higher and higher level of efficiency and effectivity. Now, in absence, and this is the area that we feel is very important, at the level of OHS, this seems to be happening collapsed in Narol area. But it is embedded into a much more bigger system where actually labor rights itself is collapsed in some sense. And the labor agencies have also collapsed, which is what actually Rahul has brought out in his article earlier. And so it is important to locate this problem, and this report actually, in a way, prefaces it and also embedded this whole concept of OHS in a larger perspective. So with this, and I think it's very important, most of these elements have come into this report. They are indications. A report of this kind cannot be very exhaustive or cannot be very, what I would call, something that can be taken into the law and made into strong evidence. But they're indicative of the kind of situation that we are facing. Now, so that's my initial comment on this report. But going forward, and this is where I would go back to Priyadarshi ji to begin with, is that in a certain sense, you understand the Factories Act better than any one of us do, because you have been a part of implementing it. And you already said so many important ingredients that this Factory Act in terms of implementation has gaps. But I want to just ask you one core question. How do you really see this Factories Act as is it primarily a prevention system, or is it a reactive system after the accidents and after things have happened? because the focus of the Factories Act would be depending upon what is the focus of the act itself and how it is being implemented. So I would like you to really talk about what is the preventive side of the Factories Act and what is the reactive side, or how does the Factories Act react to a case that emerges in the field. And what would you think would be the most important role of the Factories Act in the present situation? Yeah, Priyadarshi ji.
Factories prevention of the safety. तो हमको क्या क्या फैक्ट्री एक्ट है, तो जो प्रिवेंशन ऑफ द सेफ्टी, तो we are taking all the safety precaution measures in industries. But sir, main thing is that we have not sufficient time. Even though 500 workers are working in factory, minimum I require 1 day for the inspection. But due to the overload, we cannot do this. The main thing is the prevention of the safety, and reaction is that after accidents, it is very difficult for us, because the owner of the factories not give the response to the death workers' families. And in legal side, we are filed the case in the court. Sir, I filed case in 1991 in Ahmedabad court. After 30 years, they are issued the summons to me last week. So we are filed the case in the court, but the court can only keep it in pending. And if the court is taken any action, fine or in imprisonment, so the result will come. The main thing is there is no dar of the court or the law to the owners. Main thing to yeah.
Okay. This brings me to you are actually coming up how it is difficult to actually even prosecute. We will come to that question later on. Uske upar baad mein aayenge. But Rahul, I would really like you have looked at the law in terms of its larger social legal aspect. Essentially, the Factories Act should have been a preventive act. The report of Shubham makes it very clear that most of the time, when you get reported accident, they are at the tip of the unsafe condition that the workers work in, which means that in terms of a system, there has been a failure of the prevention. Now, can you elaborate a bit on that and show what are the aspects of the Factories Act in terms of laws or practice, where there's a major gap in terms of prevention?
Yeah, like if you look into the Factories Act, which was drafted in 1948, so it was necessary steps to prevent any kind of industrial accident and workplace injuries. But over the last 15-20 years, you may have seen now most of this accountability was on the entrepreneur or the employer who's supposed to maintain like a safety, industrial safety and everything. That has been now instead of the strict enforcement, it has become, like a soft compliances. So like in 2000, early 2000s, we can say that when we introduced the self-certification schemes into the labor compliance, because I'm working on that project right now. So as a part of that, the employer or maybe industrial unit owner has to comply, like he has to give it in a written like a writing that okay, he has taken care of everything. So there is no deterrence effect on the part of the employer, because he or she doesn't scared about, like if they are not maintaining minimum requirement, and if something goes wrong, so they will be caught. So that's the first part. The second part, Director of Factory Services, which is there at the ministry, which look into safety, factory safeties, that look into that. Only 32,000 units, industrial units in the whole country, which we have a 35 lakhs, units. They only reporting, like they have given, factory safety licenses. And that is also irony, and I agree with Mr. Priyadarshini also, there are no enforcement. Only 1,179 industrial safety officers are there in the whole country, and how they will also make sure that the compliance is. The second thing is that like we have to take into account, because Narol comes under the urban areas. And this also responsibility of the municipal corporation, Ahmedabad municipal corporations. And Ahmedabad municipal corporations, like any other corporation, has also the factory and safety officers. So where is accountability also on them also? So we are not looking into only the labor versus, like employer, but we have to put multiple accountability on the city planners and the city administration also, which is the local government administration. So here also the labor law doesn't talk about it, doesn't fix the accountability on the municipal corporation, because they also they have the capacity, because they under the Shops and Establishment Act, they are the primary enforcing authority. They give licenses to the industrial units, so we have to put the onus on them also. So that's the second part. And the third part, do we have a stringent provisions under the Factories Act? I'm sure, okay, the learner Gayatri ma'am is there, Priyadarshini sir is here. Do we have any criminal sanctions or maybe the criminal punishments on the within the Factories Act if the industrial safety is not maintained? What kind of a punishment we have? We do not have. And as you know, I've been writing about that. In the gaze of ease of doing business, and in which state, and the Gujarat is one of the states that promote ease of doing business. So we are compromising on our labor standards, and which is not going to help the Gujarat economy and the Gujarat industrial workforce also, because because every growth will come at the cost of the workers' health and injury and the industrial accidents. So in the long term, it is not going to be beneficial to the all stakeholders.
Yeah, that's an interesting take on what you see in terms of the failure. I do agree, and I think I want to emphasize that when companies decide to, when government decides to make soft compliance and self-declaration, there's an assumption that the industries would actually have intention to fulfill their obligation under the Act. That works. Soft compliance and self-declaration works only when you have that assumption validated by reality. Shubham's report shows it is invalid. When you have a 95, 98% of total disregard for law, then the question of soft compliance and self-declaration becomes absolutely a mockery. So I think this is where the question is, that if the factories, the problem is that why, in a way, the prevention is the best mechanism to see actually that there is actually a compliance system working out. If, as Priyadarshi was saying, that in a way, the very nature of the factories, and this is my observation, that in the very nature of the linking up of actually all they want is a clearing of the factory plans and factory permissions. So when factory permissions are the primary task of a factory inspector or a factory department, which is linked up to a formality to give industrial permission, then the question of prevention almost goes down very by nature of its balance of mechanism. And I think this is one of the fundamental flaw which I see in terms of the provisions of the factories. It was meant in a place when industrialization was just taking off in India. It has to evolve, it has to change, because you have to delink the whole idea. Anywhere where the modern world of OHS has come up, we have come to a very, very clear understanding that the prevention has to be a job of a far more specialized body with adequate mechanism, adequate power, and adequate transparency of what they're doing. The second important part is there no transparency of the prevention mechanism. We don't even know whether the reports are coming up in regular fashion or not. We actually, like what was just told by, I think, Priyadarshi ji said, and I think Shubham also said, there are a large number of factories which have been given permission to run without getting a license for the fire. So these are all really two core points which I would really say is that somehow adequate preventive framework and a systemic mechanism to see that the prevention is implemented. Let's talk about the violation later on. Even that actually is a far more administrative framework than it is today, which is a very, very, I think this is what the report brings out in a very strong way. So moving from this, and this is where I would go back to the second core question that I want to pose before the panel, is that there is a, there was a recent incident in which one of the Narol area, there was an accident and there was a death. And suddenly the Prime Minister's office gave a compensation, and the world became great that, there is such a high level of compensation began to one case. But I think what Shubham reports kind of gives out and weaves through the process, that is a very small part of how the system is working in terms of things. Now this shift, and this is where Gayatri, you would really come into, and both you and Jagdish, I would like you both to speak, that should it be, is addressing negligence, two questions, is addressing negligence, is addressing it by compensation is the best way of addressing negligence? And second, is the compensation adequate enough in India to actually make a deterrent and force the people to become non-negligent compliant? So Gayatri, I would like to have your view on this and your experience on this.
I would just like to rely on a judgment of the NGT, which basically dealt with this issue of compensation, and very, very briefly deal with that, because that could be an alternative way of looking at it. Right now, we deal with compensation from the point of view of the Workmen's Compensation Act. As I said, it's very paltry. And basically, even after workers file it, or the government files a case, it takes several years to get compensation. Now, in the case of a factory in Bombay, in Maharashtra, near Pune, there was an explosion, and the company, the factory inspector and the directorate, the Dish, a person from Dish inspected the place after the explosion took place. And it was found that the factory had no license. The plans that were approved subsequent, just about 2 or 3 months before the explosion. So the aspect of enforcement again was a major issue, and that came up in an NGT matter where the NGT suo moto decided to take a call on these deaths that were taking place in explosions and blasts and so forth. So that was a suo moto petition, but in that they dealt with the issue of compensation. And there were two aspects to it. One was, as far as statutory compensation is concerned, there are laws relating to, of course, Workmen's Compensation Act. Then you have the Carriage Acts, which is basically the Air Act, the Railway Act, and the Motor Vehicles Act, under which different concepts of compensation have been set out, which also include issues relating to loss of estate, loss of spouse, loss of etc., etc. So there are many other aspects which have been considered under those provisions. The third aspect, and I think we should develop the law with regard to that, is the issue of public law remedy, which is really a very, very important point. And that in that regard, the NGT dealt with 2-3 cases, and I just very briefly deal with that because that's very, very important. One was the judgment in the UPA. So there were 3 categories. One was the category of statutes. Those are where you claim compensation under a particular statute. And the second, as I said, public remedy. Under that, there were three different categories. One was a category where deaths took place due to explosions, fires, or because of so-called terrorist acts, etc. And in the case of Upar judgment, the court said that the compensation set in Upar was in the case of, first of all, it said that it is absolute liability. There's no question of going into whether it was due to negligence, etc. It was an absolute liability as far as the death was concerned, and therefore the compensation that was declared was 10 lakhs for those people who had burn injuries and who were above 20 years. Then it was 7.5 for those who were less than 20 years, and 1 lakh who were basically outpatients who were treated and then discharged from hospital. The second judgment was of the Sanjay Gupta case, where there was a massive fire in a show which was organized by a private party, but after seeking permission from the state. And the court held that the state was equally liable because it did not take the responsibility of ensuring that their permissions had been properly obtained. And an interim compensation of 30 lakhs was awarded to those who died due to the fire. And the third case was of a boat tragedy case where children died due to the sinkage of the boat, and the children were paid 5 lakhs, which was a small amount, but that was based on the concept of absolute liability. So I think that we need to go into this issue and take up the issue of public law remedy with regard to payment of compensation, because there are two aspects to it. As Oshim said, it's not just the issue of compensation for the victims, but it's also punitive damages for the against the state, which has failed in its duty to ensure that proper permissions have been obtained and that safety has been maintained. So it's both punitive as well as compensation. And I think that needs to be developed with regard to enforcement of law and making it punitive for both the employer as well as the state government.
Rahul, you want to chip in anything on this point before I?
No. I completely agree with the ma'am. Why we are not taking into the class action suit, because after the Bhopal gas strategy, the Indian labor jurisprudence has actually defined the class actions, and then we have to take it into very seriously in that. Most of the time, the workers who are actually getting compensation under the Factories Act, they are mostly settled outside the code. And this is also a tendency where the management engage into that practice, says that, okay, we will give you, like a 50,000, 1 lakh rupees as a compensation outside the code, so you don't take the matter to the court. And as a result of that, many entrepreneurs and the employers, they go scot-free because they are not been treated, they are not been held accountable in the court of law. And as a result of that, these injuries goes undetected. I wanted to highlight another more important point in this case, the role of a Directorate of Factory Services, and then those who maintain the safety standards, because I've been looking into these matters very closely. Factory compliances, when they give permissions to have a factory, so they go back to the definition of hazardous industry. So I was wondering that from where this definition comes from, the hazardous industries, because in the hazardous industry it is mandatory, but who defined that thing? So last meeting they held, it was in 2003, where they defined what are the hazardous industry and what is not the hazardous industry. Because I have worked for the one paper for the another agencies where we have looked into their proceedings of the. So this definition comes from the Environmental Protection Act, that gives the definitions where the hazardous industry definition comes, and the Factories Act implement that definition. So the revised format, and you must have seen in the recent Child Labor Act, the definition has actually narrowed it down in order to give more leeway to the family enterprises. As a result of that, we are not able to fix the accountability. So as a labor researchers, my interest would be to fix the accountability on the worker, on the employer, so that any kind of industrial injustice will be detected and they will be prevented. Because unless and until we don't have a strict laws on that, we are not able to change the behavior. And also one point, like I was going through the Constitution Assembly debate, and when the Factories Act was drafted in 1948, I still remember the quote from the V.V. Giri, where he mentioned about that if we put strict provisions into the Factories Act, Indian entrepreneurs are actually going to be afraid. They will not set up their factory. So Indian government, since the independence only, we had that apprehension that the Indian capitalist, okay, if you put strong law, they will get, and then we go by the trusteeship rules. Okay, we will trust them and everything. But now the time has actually gone, so we have to deal with the strict rules which is there in other countries too. So we have to have a strong laws. And in today's labor code also, when I looked into industrial relation and the
we'll come to this question a bit.
Sure. Thank you.
I know you have a lot of things that Jagdish bhai, you have been kind of one of the pioneers in outsourcing, I remember, no one really bothered about the informal sector, and you got compensation for silicosis
Yeah.
in aggregate workers. So you have a huge experience about that of getting compensation for the workers, and that has been one of your very strong and strength of your work. From your long experience, what do you think the compensation has affected the industry in making them more safe? Have their compensation has been adequate enough to push them to more safer processes? And how has the industry responded to this compensation?
Well, I don't think that at least Employees Compensation Act has fulfilled that objective to work as deterrent. Because in most cases, the workers who are not covered under ESI Act, they have to seek compensation under EC Act. And under EC Act, the moment worker files a claim, he will be fired. And workers know about this. So most workers don't want to file any claim under EC Act. Those who dare to file compensation claim, then it takes time, as Gayatri has already mentioned. And after the court, that is compensation commissioner, is ordering some amount of compensation, the compensation is not paid at all. Because in one of our cases, when after a lot of effort, the court ordered to pay some 53,000 to a worker. The worker went, it was an ex parte order because the employer did not present in the court at all, anytime. So then we asked the worker to go to his employer with the copy of the order. And employer tore down the order in his front of the worker and said, okay, go wherever you want to go. I'm not going to pay. Now worker came to us that this is the reaction from the employer, what to do. So then we approached the collector and asked him to help us. So he rang up Mamlatdar, and Mamlatdar, I think, spent 6 months and no result was came. So then we went to High Court. When we went to High Court, the employer petitioned to the court that, sir, please put me in jail because I am not able to pay this 53,000. So the court ordered that, no, we cannot put you in jail. We want you to be out. We want you to continue with your business, earn some money, and then pay some. So then he said, sir, then I need some time for that, and you should give me some relief and that, this and that. So then court said, okay, you can pay 10,000 rupees installment, and in 5 installment you have to complete this 53,000. He said, okay, sir, I'll do that. For us to get first installment, it was a case of the job, and to complete the amount, it took, I think, 2 years or so. So this is the whole experience of Workmen's Compensation Act. Of late, I wish to draw to attention of you all that the government of Gujarat has made it a policy not to file any complaints against the employer if he is violating the law and that has led to the accident. If the employer is paying ex gratia compensation to the victim. And CAG, CAG has criticized this policy, and in spite of it, government has not changed this policy. It has further said that even if a complaint has been filed, it will be withdrawn if ex gratia is paid. Now in this policy, they have not named what ex gratia is and how much ex gratia. So even if he is paying some 2 rupees more than legal one, this will be applicable. So this is a very dangerous trend that the state governments do not want employers to be taken to the court. And as Manubhai rightly said, that in many cases the complaints when filed, they are dragged on for years and years, and the desirable result you do not achieve going to court. So now, recently, government of Gujarat has given some powers to the inspectors to levy the fine to the violators. We don't know how far it will work, but many a times we see that the trade unions or the workers and even government, they uh, join this compensation and violation. Okay, compensation has been given. Why you should worry about the violation? In Gujarat Refinery, which is a public sector company, they were.
Okay, everyone can't hear him, right?
Yeah.
Okay, let's move forward because I think we're already short of time. I would, last question to the panel, and this is the most important. I think Gayatri has, actually opened up and actually suggested, which is very important, that in order to enforce, we'll have to actually have, in addition to the statutory law for factories, whatever we compliance system and the mechanism of compensation and things like that. There has to be some public policy system that should really be built, which means bringing up the agency in a different form, which means alternative methods of actually seeing that the enforcement take place. That's one very important area. I would really like to everyone to have a quick thing as to what are the assumptions that we normally hold about implementation of the law cannot be held. I would say that when impunity, of law is so wide and so widespread, then you cannot have a possibility that the industry would actually do a self-correction itself. That's one assumption that should be discarded, and we should really build a framework on that. So what could be other assumption? I remember section 111, which actually gives the mechanism for complaint to the Factories Act. The assumption is the worker will do it. Now, if you have a worker, like what Shubham's report show, first that he's unorganized, second he's contract labor. That is a dominant part of the factory is under migrant worker, unorganized, fragmented into a number of contracts. It's impossible for the worker to ever make a complaint. It will be an exception. Then the question comes up, who else can be the agency? Can it be any union or can it be only representative of the workers? The law is very undefined inside it. So that's one major weakness that we have. That we can kind of look into it. So how can actually civil society, how can actually the other unions and public bodies can actually do this? This is a question of how to really think. The other the second point which I want to really ask your take on all of you on this is that if you consider it to be this assumption that it is you have to be less safety compliant if you want to have faster industrialization. This assumption is like something to be secretively done, So it follows from that is the idea of non-transparency. What is non-transparency of a factory report that shouldn't be available to the people? One of the best ways that other European countries have done is to make every OHS report and orders to be transparent. It's available on website, so people can know exactly what has happened to that place. Now, transparency is very important. On that, how does the system that exists today can be made more transparent is another, and who can do it is a question that I like to pose of you. So I think we'll begin with Rahul and move in order with everyone to give it quick. I think we are short of time. So we'll give you 2 minutes to really respond to these questions. I know it's a big question. We haven't even come to the idea of problems of double jeopardy and the way how the laws have been enforced in terms of punitive act, in terms of compensation, but I don't think we have a time for that. Let's respond to these questions quickly.
Yeah, thank you, Ashim sir. If you look into the occupational safety code, also OSH code, there also the maximum penalty is 2 lakhs rupees, and it can go up not more than 3 lakhs rupees. So if you put like a civil sanctions into the code, and then there is no deterrence effect, then employers will be they can easily go scot-free. That's the first problem. Second one, all these establishments, especially in the textiles, are happening into the 90% comes from the unorganized sectors, and in unorganized sectors there has not been any significant effort to formalize them, and hence even the contract labor, though we have a law which actually prevents and eliminates the contract labor systems, but still we are not able to fix the accountability on the principal employer, because it is so many third party transactions are there and related systems. And the third one, still in the act, we do not have third party audit. That is more important, that if the employer is not able to provide, we need to have a third party audit systems, which is there in the there are many European countries where the third party does the audit of the industrial premises and they make a recommendations. So for that, we really need to have a robust administrative systems that can actually help us. But since like in the labor, since the nomenclature has changed, and in today's context, we call the labor inspector the inspector cum facilitator. So his like jurisdiction powers or her jurisdiction power has actually actually come down, and then people really don't like care about enforcement agency, and that is really troublesome. It's like whenever any kind of a criminal activity happens, so we always invoke, okay, there should be more police, and that's typical logic we give. But whenever the more industrial hazards happens, do we have enough industrial safety officers in the country that can prevent? So that the question we really need to ask. And why the most of the time out of court settlement happens, that is also another management practices that really need to brought in. Okay, this is not a civil matter, this is a criminal matter, because somebody had injured, somebody had like accidents, many people lives and their family lives are at stakes, and we really need to bring these questions to the forefront, that okay, why it is taking like so much time, and why we are not giving law to take its own course, rather than we are relying on the management practices. And then we have been doing, I'm really thankful that these reports actually talked about which is the gray areas in the law, industrial injuries nobody talks about. We read in the newspaper every day some factory, and during the lockdown, and that was also I have been referring, during the lockdown when the factories was closed, no inspection was happening. After the reopening of the factory, all these industrial accidents has actually taken place because maintenance was not there, safety precautions was not taken care, and poor and precarious worker has to sacrifice their life because of the negligence by the employer, and there is nobody who can actually take care from.
Okay, thanks, Rahul. Manu bhai, one very pertinent and direct question. अगर हम लोगों ने ट्रांसपेरेंसी फैक्ट्री के जितने भी आपके प्रोसेसेस होते हैं, डॉक्यूमेंटेशन होते हैं, रिपोर्ट्स होते हैं, उसको ट्रांसपेरेंट कर दिया लोगों को, उसका पीपल कैन गेट एक्सेस टू इट, पब्लिक बॉडीज कैन एक्सेस टू इट, और एनजीओज कैन, यूनियंस कैन, उसमें नुकसान क्या हो सकता है? क्या ये इससे हमारे इम्प्लीमेंटेशन के प्रोसेस में ताकत नहीं मिलेगी, या उससे वो कमजोर हो जाएगा? आपकी, क्योंकि आपका अनुभव है, मैं जानता हूँ लॉ सरकारी प्रोसेस में बहुत मुश्किल है, पर इसको अगर हम एक हमें जिसे वैचारिक रूप से देखें, अगर हम इसको ट्रांसपेरेंट, इसको खुलेआम कर देते हैं, लेट ए पब्लिक इट बिकम एन वेबसाइट, एवरीथिंग कम्स अप रेगुलरली, तो उससे नुकसान होगा कि उससे कोई नुकसान हो सकता है?
नहीं, नुकसान नहीं हो सकता है, वो अच्छा रहेगा, क्योंकि पब्लिक में जो ट्रांसपेरेंसी हो जाएगी तो पब्लिक और देन एक्सपर्टीज आल्सो गिव देयर सजेशन, तो हम कुछ अच्छा इंप्रूव कर सकते हैं।
और ये मुमकिन है, ये मुमकिन है।
हाँ, हो सकता है,
मुमकिन है। एक वेबसाइट का, फैक्ट्री एक्ट का वेबसाइट है, और हर इंस्पेक्शन रिपोर्ट उसका पब्लिक हो जाता है, तो हाँ। ये आरटीआई का झमेला, ये सब इसमें इट्स नॉट समथिंग दैट इज वेरी डीपली सीक्रेट, इसमें कोई सरकारी तंत्र का कोई बड़ा हम लोग कोई सैबोटेज कर देगा, ऐसा तो होने वाला नहीं है। तो इसलिए ये सब चीजें में जितना इन्फोर्समेंट खुलेआम होगा उतना अच्छा रहेगा। दैट इज व्हाट आई थिंक लॉट ऑफ द पीपल वुड फील।
सही है, दिस इज अ गुड आइडिया,
ओके। एंड अगर इसके बारे में सरकार से बात करें तो इट विल बी समथिंग दैट पीपल कैन टॉक अबाउट इट, इट इज समथिंग दैट वी शुड डिस्कस विद द गवर्नमेंट।
या
ओके, so I will before I go to Gayatri for the last word, जगदीश, यू मिस्ड आउट, आप कुछ बोल रहे थे वो खत्म नहीं कर पाए, बट उसके अलावा ये जो इस पूरे OHS को लेकर आपके दो कोर पॉइंट क्या हो सकते हैं कि जो आपके एक्सपीरियंस से ये है कि इसको हम जब तक बदलेंगे नहीं तब तक हम अमल नहीं कर सकते? if we don't challenge certain assumption, two assumption that is there, we will not be able to implement it very well.
हाँ, एक तो मुझे ये लगता है कि राइट टू रिफ्यूज अपने कानून में नहीं है, कि वर्कर को लगता है कि यदि यहाँ काम करना डेंजरस है फॉर माय सेफ्टी एंड हेल्थ, ही शुड हैव राइट टू रिफ्यूज, जो आज नहीं है। आज हमारे पास जो राइट है इज ओनली एन रिपोर्ट ऑफ इमिनेंट डेंजर, तो और वो भी है सेक्शन 41A में हैजार्डस इंडस्ट्री के लिए, और ऐसा उसके लिए नहीं है। तो और इमिनेंट डेंजर में भी यह है कि इमिनेंट डेंजर में तुम दोगे नोटिस, तो इंस्पेक्टर विल हैव टू कम एंड इंस्पेक्ट योर वर्क प्लेस टू ascertain whether your complaint has substance or not. So this one change we should be demanding is right to refuse. दूसरा जो है the powers for prosecution are lying with the inspectors, that is government only, and government has full control over it. We should be demanding prosecution powers for the workers themselves, trade unions and civil society organizations. And this may open up a new avenue, and there should be also a provision that if that succeeds, then the amount of fine will be shared between the petitioner and the government. So that will be an incentive or encouragement to the petitioner. I was talking to the trade unions of Nordic countries, and they were saying that our trade union has a major source of income is this type of complaints they are filing in the court, and they are earning a lot of revenue out of it. So that is an encouragement, and that can go a long way in ensuring better, safer workplaces. That's what I think.
Okay. So Gayatri, the last question of this discussion is to you, is that you have actually opened up the idea that there is a public law remedy that is emerging, and that's like earlier public litigation. Now you have a public law remedy emerging, and it's a very interesting because it actually builds up on the idea that there is a possibility of enforcing punitive punishment and punitive damages to the body and to the institution entity. So how, this breakthroughs that is happening in the few cases, you are both an organizer as well as a lawyer. What is your suggestion? How do we integrate the trade union movement to this new opening up and build up a powerful instrument and powerful process by which the trade union can combine with the public interest and public law remedy to enforce? What would be your quick suggestion to how we should go forward in this direction? I think it's a very important element.
So one would be that we instead of taking the route of the labor courts and industrial court and civil courts, we go directly for compensation and for penal damages to the High Court, and in some cases to the NGT. The restriction as far as NGT is concerned is because it involves only environmental law. But as someone was just saying, some of the aspects, like for example, the hazardous, the chemical accidents rules, the MSIHC rules which deal with chemicals, have been rules which have been framed under the Environment Protection Act. So those are the rules which we can rely upon if we want to go before the NGT by saying that this is a breach of the delegated legislation under the EPA and these have been violated. If we all, I have sent it to Shubham, I have sent the judgment which covers all the cases of the accidents which have taken place in different parts of the country, from Andhra Pradesh, Gujarat, Orissa, Bengal, Maharashtra, etc., which the NGT has dealt with regard to those accidents where people died as well as those who were injured. And this whole concept of the rules being followed, not being followed under the by the different states, and two, with regard to compensation, has been dealt with at great length, and I think we can adopt those arguments as far as the principles for punitive action is concerned. The third aspect is that that not only does it deal with preventive action, it deals with compensation. And the third most important, which we have not discussed, is the restitution. That it's not only question of prevention and compensation, it's also question of restitution, that is to ensure that these accidents do not take place and to rectify the situation. So it involves not only the workers, but also the residents in the vicinity who have been affected by the accident. So it becomes a much more overarching action instead of just being restricted to that particular factory. That's a third thing. And lastly, I would just say, as Oshim said, I think transparency is the most important issue, because if you look at the OSH codes, there are specific provisions which prohibits disclosure of information. So you have at least 2-3 sections which say that neither the factory inspector, the facilitator, nor the workman, or anyone who has possession of this information can disclose information to anyone. And if it is done, they can be prosecuted. So instead of prosecuting the employer, you're prosecuting the victims. And I think this needs to be taken up seriously, because this is going to become the law in the near future. And finally, I would say that as far as prosecution to the employers is concerned, the code also basically exonerates the employers. What it does is it says that any employer who does not comply with the provisions of the law will be fined with 2 lakhs. Okay, so that's the only thing that will be done to him. Secondly, if he falsifies information or he gives incorrect information, then he will be imprisoned for 3 months or with fine. So we all know imprisonment will never take place. It will be a minuscule amount of fine. And the third aspect is that in cases of prosecution, where the factory inspector with great difficulty manages to prosecute the employer can come forward and say, now I have rectified the situation. Like someone was saying, like Jagdish was saying, I paid compensation. Therefore, I've rectified the situation and I should be now exonerated. And on that basis, he can be exonerated and the prosecution can be withdrawn. I mean, this is a very, very serious aspect with regard to the codes which are going to be implemented, because it basically does away with, besides all these provisions, it also has provisions which does away with enforcement and implementation of the law. Of course, the codes, as everyone knows, has not really set out details of what the safety requirements are. It basically leaves it to the central government and the state to frame rules, and those rules will then become applicable as far as individual states are concerned.
Thanks very much. This is very, very good. I just want to kind of finally just say one thing about this aspect, is that it is amazing that in the last 70 years now almost, there's hardly actually union movement which has, and this is a self-critical way of looking at it, has actually taken a fight and taken it to Supreme Court on the Factories Act. I'm shocked actually to understand. It's only after I got involved with the Ajivika Bureau and started looking into the idea of accidents in such a scale, that section 92 is so flattened. It's negligence by death. And if you don't put a fire extinguisher in a proper place, the punishment is almost same. The prosecution is almost same. And this, and you know, when Manubhai was saying he has been called after 30 years, because for 30 years in Gujarat, this is one of the things that has happened. The criminal court never dealt with any of the Factories Act. After 30 years, there are more than 10,000 cases that have got accumulated. So one day they bring everything, give it to the labor court. Labor court doesn't even try it. Labor court says, let's have a, what is called Lok Adalat. And Lok Adalat, sabko 10 rupiya, 15 rupiya, aap unko bol dete. So basically, a person whose negligence led to death, and to be honest, Supreme Court has not taken a view on that. There are now contrary to High Court judgments which have taken a different view. But the fact is that it has not reached Supreme Court is also a lack of how the union movement, and that's why it was very important, the agency of the workers haven't really taken this also seriously, is one of my own personal conclusion. And I think we are all guilty of it in some fashion. But I think Shubham's report actually will trigger. I really think this will energize, and we will make, I think a lot of elements have come in, and I think we can actually build up a a public interest process here and see how we can go forward. Thanks Shubham for really triggering this, and thanks Rajiv for taking this energy. And I think Ajivika Bureau has actually brought a lot of these elements together in the Narol area, and I'm looking forward to really seeing that we can move forward with all the lessons that we are drawing from here. Thanks all of you who are in the panel, Jagdish Bhai, Rahul, Gayatri, Manu Bhai. I think this is one of the best panel I have actually seen on OHS, honestly, which has not been rhetoric, but which has been very, very specific, pertinent, and pointed. So thanks for Ajivika Bureau to bring this panel. With that concluding words, I would give back to Rajiv to conclude the whole session. Thanks, Rajiv.
Okay, thank you very much, Oshim, and I agree with you. This has been one of the most engaging conversations I've been part of. Thank you for bringing so much experience and so much activism to the findings of the report and giving us such valuable pointers for the future. While listening in, I was trying to capture some of the main points, some of the central points that all of you made, which will help Ajivika Bureau and our partners, the union, taking forward this report into the space of action, possible litigation, and to help make Narol a safer, more secure space for workers, but also to take its lessons forward to the wider realms of industry. So, thank you, Ashim. I think it was very usefully located the report in the context of deregulation and the weakening regime of labor laws. And I really like the way you formulated how modern industrialization had failed entirely to take prevention as an essential prerequisite to productivity and to workers' welfare. It has actually delinked the two, and industrialization being based on ignorance of compliance and regulation will not sustain. With that point, I think finds a lot of echo. I also really agree with your point that self-declaration will not work because it assumes compliance, and where the whole both morality and enforcement are so much a doubt. So self-declaration is probably not the tool to take as a valid one for enforcing higher standards of safety and security for workers in spaces like Narol. I think that was an interesting observation or interesting kind of recommendation, that what if you were to make all the records transparent in the inspection and compliance system of the Labor Department, and which can therefore be accessed more easily by trade unions, by NGOs, by workers' representatives themselves. I think that's a powerful recommendation. And also thank you, Ocean, for moderating this panel so sensibly, and you actually knew what to ask everyone, which speaks to their experience and their expertise. From Gayatri, I think Gayatri's emphasis on the need for enforcement and compensation, and not just prevention. I think that's really important. That's really important for us to note. I think she suggested that we should approach compensation in public law, and not just, and then move away from just accepting smaller sums, which are out of court or just done through kind of more minor kind of mediation time, rather than, and actually look at what punitive damages can be paid by employers and state, which will act as a stronger deterrent, right? And also allow for third-party compensation claims, right? Which I think will serve as a better signal to the industry that safety standards have to be upped and compensation has to be definitely provided, not just in a tokenistic way, but in a significant way. Yeah, I think the point that you're making, Gayatri, is that the OSH code and the weakening of the opacity of compliance and investigations, which actually will let employers get away by removing their criminal liability and by reducing the penalties. That's a very serious one. And I think this is what makes action on something like this really important and really timely. Jagdish Bhai, thank you for suggesting very many radical measures, which in the growing environment of deregulation are, and in opacity of
good action. That I think those measures are very important. I really picked up on the right of refusal to work by workers that must be strengthened along with a power to prosecute for non-compliance. I think, again, this speaks to the points that Oshim and Gayatri already made. I was very interested to hear what Mr. Priyadarshi had to say, and he was very candid in admitting the state of affairs in the both labor department and the fire department, which are both occupied by personnel who are not competent to assess or enforce safety standards, and lack of knowledge of factory fire hazards and lack of knowledge around the national building code in factories is a major kind of a issue and it's challenge. And maybe we can think about building capacities in that area so that there's more information and awareness on what law actually holds. But of course, all of this has to rest on more resourcing and better staffing of the departments that are supposed to regulate and enforce. I'm glad you spoke about the new fire safety laws, Shivan. The industry in Gujarat are actually currently not even required to obtain fire NOC. So with that kind of easing out, I think the what we can bring as necessary mandatory action for safety is really jeopardized. Rahul, you spoke extensively about how the report establishes a very strong evidence, which brings the causal link between the deregulation and the compromise on workplace safety. This is what happens when you deregulate both consciously and unconsciously. This is what the outcome will be on workplace safety. And I think your case is a strong one for reading the ILO Convention 87 into the law itself. And especially as we know here, and from your research, that the increases in the accidents post lockdown are an evidence of why more, not less, needs to happen. Again, I think the point that has been made earlier, which you also made, Rahul, is how do we bring tort law? How do we bring tort remedies into the law and allowing third-party auditing systems that some European countries are following? I think those kinds of new ways have to be found for industry. I have to say that recently I've been part of conversations with industries, especially in the manufacturing space, some very large scale industries, and I've had the opportunity to visit some of their sites, their facilities, and have been very impressed with the standards of safety that are followed in their own facilities. Right now, these are of a very high order for their own workers, but for their on-roll workers. But of course, almost between 50 to 70% of the entire workforce is contract workforce. As far as the facility is concerned, safety standards apply equally to the workers on roll as well as to those on contract. It actually diminishes very rapidly as soon as we come to the supply chain, to the vendors where the material is being procured from, or even to the front end kind of distribution channel partners and so on. But a lot of industry leaders are saying, not just in a tokenistic or in a ceremonial way, they're saying why it is important and how they are prepared to invest in higher labor standards, especially in the domain of safety and ensuring that workers' lives or limbs or health and well-being is not compromised, and laying that out as a qualifying criteria for making business partnerships. And I think there is some space there, where state regulation is failing. Maybe at least we could also think about working with some of the larger, more responsible and far-sighted businesses who are prepared to see labor standards not just as a CSR activity, but actually as a matter of core business, and how investing in better standards would also result in better returns and profits. So I think with all these observations, we have a lot of very rich inputs from all of you. Thank you so much for that. This report does absolutely, the work of the report does not end here. In fact, if anything, it begins from this point. We are taking it to the workers, constituency, as well as we'll look at how we can use the tools that are available to us in law to bring more enforcement and compliance, but also see what is the power of persuasion possible with industry, both in Narol and in other locations. So thank you again, and thank you, Shubham, and the team to have conducted to have carried out such a brilliant piece of research. And thank you, Ashim, for helping us put this together.